This podcast episode will concentrate on the various dispute resolution processes that are available to management and employees to help them solve their differences. Dispute resolution is the series of processes or steps that employers and employees go through to solve their employment relations problems. These processes are grievance procedures, negotiation, mediation, conciliation, arbitration, common law action, and business or division closure. The first 4 of these processes will be explained in this podcast. The first process that managers and employees need to go through is a grievance procedure. When an employee has a grievance in the business, a grievance procedure is a series of steps that the business has in place to allow this grievance to be handled effectively. An effective grievance procedure allows problems like pay disputes, bullying, safety, etc. to be solved before they become major issues. Grievance procedures were explained in detail in PODCLASS 11, Effective Employment Relations, Communication Systems. The second dispute resolution process is negotiation. These are formal and informal discussions between management and employees, and could be part of the first step of a grievance procedure, or could be a step beyond this where negotiations involve the trade union, lawyers, the employers' association, etc. If the negotiations are successful, then the dispute is resolved at this level. The next stage of the dispute resolution process is mediation. Mediation occurs when the negotiations are not successful, and an independent third party called a mediator is brought in to hear both sides of the dispute. Fair Work Australia and the New South Wales Industrial Relations Commission often act as mediators in employment relations disputes. The mediator helps to guide the discussion and helps both sides to listen to each other. However, the mediator does not impose a decision or make any judgment. If mediation does not work, the next step is conciliation. As with mediation, the dispute is again referred to an independent third party, and again Fair Work Australia and the New South Wales Industrial Relations Commission usually act as the independent conciliators. Like mediation, the process of conciliation attempts to reduce tension between the parties and improve communication between them. Unlike mediation, the conciliator usually recommends a solution to solve the dispute, but this solution does not have to be accepted by the parties. The next PODCLASS episode will examine the remaining 3 dispute resolution processes: arbitration, common law action, and business or division closure.